Hello everyone, welcome to the channel Scientellectual. The current video provides the information regarding the sections 89 and 90 under Indian Patents Act 1970. These sections come under Chapter 16, Working of Patents, Compulsory Licenses and Revocation. First, we are discussing Section 89, General Purposes for Granting Compulsory Licenses. When an application is made under Section 84 for requesting of compulsory license, then the power of the controller shall be exercised to secure the following general purposes. The purposes are that the patented inventions are worked on a commercial scale in India without undue delay and to the fullest extent that is reasonably practicable. Next, that the interest of any person for the time being working or developing an invention in India under the protection of the patent are not unfairly prejudiced. Next, we are coming to Section 90, Terms and Conditions of Compulsory License. What are the terms and conditions that are related to compulsory license? Number 1, the royalty or other remuneration, if there is any, reserved to the patentee or other person entitled to the patent is reasonable. That is, the patentee or any other person entitled to the patent will have reasonable amount of royalty or remuneration. Having regard to the nature of the invention, the expenditure incurred by the patentee in making the invention or developing it and obtaining a patent and keeping it in force and other relevant factors. That is, how much royalty or remuneration the patentee or the person entitled to the patent will be given, that will be reasonable, and the factor on which it will be decided how much they will be paid is related to the nature of the invention or how much expenditure they have made in making the invention or developing it or obtaining the patent or keeping it in force, etc. Next, number 2, that the patented invention is worked to the fullest extent by the person to whom the license is granted and with reasonable profit to him. That is, whoever will be given the license of the patented invention, he also will be given reasonable profit. Number 3, that the patented articles are made available to the public at reasonably affordable prices. That is, the patented article for which the compulsory license will be granted, that should be available to the public at reasonably affordable prices. Number 4, license granted is non-exclusive in nature. Next, number 5, the right of the licensee is non-assignable. 6, the license is for the balanced term of the patent unless a shorter term is consistent with the public interest. That is, how much term is left with the patent, that will be the balance term, and that is the term for the license. Number 7, license is granted with a predominant purpose of supply in India or Indian market, and that the licensee may also export the patented product if need be in accordance with the provision as discussed under section 84(7)(a)(3). Next point, in case of semiconductor technology, the license granted is to work the invention for public non-commercial use. Next point, in case of license is granted to remedy a practice determined after judicial or administrative process to be anti-competitive, the licensee shall be permitted to export the patented product if there is any need. Section 90, subsection 2. No license will be granted for authorizing the licensee to import the patented article or an article or substance made by the patented process from abroad, where such importation would, but for such authorization, constitute an infringement of the rights of the patentee. That is, importation is not allowed. So far, it is an infringement of the right of the patentee. Subsection 3. Notwithstanding anything contained in subsection 2, that is, whatever has been mentioned under subsection 2 of this section, the central government may, if in its opinion it is necessary in the public interest, direct the controller at any time to authorize any licensee in respect of the patent to import the patented article or an article or substance made by the patented process from abroad. That is, if necessary for public interest, the central government may direct the controller to authorize the licensee for importation the patented article or the article or substance made by the patented process, subject to such conditions as it considers necessary to impose, relating among other matters to the royalty or other remuneration, if any, payable to the patentee, the quantum of import, that is, how much quantity has been imported, the sale price of the imported article, period of importation, etc., will be counted, and thereupon the controller shall give effect to the direction. Thank you everyone for watching the video. Please give like and please share and subscribe the channel Intellectual. In our upcoming videos, we will be covering the rest sections under Compulsory License of Indian Patents Act 1970. These will be very helpful during the preparation of Indian Patent Agent exam. Thank you once again.